Hi, I want to talk about a concept that is called constructive dismissal. Constructive dismissal basically means that the law will construct certain conduct of the employer to be the same as if the relationship was legally terminated. That in turn will give rise to the usual claims an employee can make on termination, statutory payments, common law wrongful dismissal, that is, and perhaps aggravated or punitive damages. So the first step is to determine, well, what is and what is not a constructive dismissal. Now, before I discuss this, there's an important concept that we have to understand, and that is if there is a constructive dismissal, the employee is going to assert the relationship is over and then make a claim for whatever entitlement that person may have had he been directly terminated. And the question you have to ask yourself before you embark on this journey, well, is this all worthwhile? Let's suppose, for example, the employee has been working for the company for, let's say, 3 years. So what's his entitlement, his or her entitlement, going to be in a wrongful dismissal claim? It's going to be fairly modest, perhaps 4-6 months max, barring anything unusual, and presuming no employment contract. So you have to ask yourself, is it really worthwhile to take on unemployment, make an assertion my employment is terminated, and make a claim for damages? So you have to do that analysis to see if this risk is worthwhile taking and the degree of the risk, as opposed to just keep on going into work every day and looking for a new job when you can leave on your own terms. So with that brief introduction, let's discuss what is a constructive dismissal. And in essence, there's two types of employer conduct that could be a constructive dismissal. First of all, is there a material change to the terms of the employment relationship that is to the detriment of the employee? It could be in that situation that the person's been demoted, given a position of less prestige and status. There could also be a decrease in income in the new position that's offered. And then the employee has to say, okay, what can I do? The second situation is where there's a toxic work environment. That is, the employment relationship is abusive. There's whatever degree of disharmony created by the employer, whether it's abusive emotionally, physically, or just a toxic work environment generally. So all those situations can give rise to a claim. Let's go back to the fundamental situation where there's a change in terms of employment. So that requires, first of all, an analysis of, well, what are the terms of employment? Is there a contract under which the person was hired? Does this contract contemplate or give to the employer the right to make these changes? And if it does not do that and changes have been implemented, are the changes significant enough to amount to termination, or are they modest, incrementally minimal changes? So these are the issues you have to discuss. And by the way, this is no time for a person driving the truck who is an amateur. You need professional advice on this because the law is very complex in this area for reasons that will be discussed in the subsequent video. So these are the fundamental concepts in place right now. Is there a change in the terms of employment downward that was not contemplated? Are the changes significant? And or is there a toxic work environment? And when you get there, keep reading because there's more stuff to learn still.